TTAB, no bright line rule against trademarks for characters. The Trademark Trial and Appeal Board has reiterated that there is no strict or bright line rule against registration of characters. Joseph A. Staller, DBA Osgood Media, sought registration of a trademark in the field of computer games. As described in the application, the mark consists of a woman video game character named Maria, with a tilted head, dark messy hair, dark eyes, thin-rimmed glasses, and a large toothy smile, with her eyes looking to the side and strands of her hair in front of her eyes. Maria is a main character in the video game, Target of Desire Episode 1. The only specimen the applicant submitted of the mark was from a third-party webpage for an electronic retail store for video games. The trademark examining attorney refused registration of applicant's mark on the ground that it fails to function as a mark under Sections 1, 2, and 45 of the Trademark Act, 15 U.S.C. Sections 1051, 1052, and 1127, because consumers would perceive it only as identifying a character in applicants' video games and not as a source indicator for applicants' goods. The TTAB affirmed the refusal, noting, Section 45 of the Trademark Act defines a trademark as any word, name, symbol, or device, or any combination thereof, one, used by a person, to identify and distinguish his or her goods from those manufactured or sold by others, and to indicate the source of the goods, even if that source is unknown. 15 U.S.C. Section 1127. A proposed trademark is registrable only if it functions as an identifier of the source of the applicant's goods or services. There's no prohibition against registration of fictitious or fanciful character marks that serve a dual purpose. That is, serve both as a character in the goods or services and as a trademark or service mark. However, in order to be registrable, the use of a fictitious or fanciful character must be perceived by the purchasing public not just as a character, but also as a mark which identifies and distinguishes the source of the goods or services. According to the examining attorney, the specimen or Maria coupled with the evidence on record shows the applied for mark is used only to identify a character, and not as a source indicator for applicants' goods. The TTAB noted that there is no strict or bright line rule against registration of characters as trademarks, but that Maria didn't qualify as a trademark in this case. Many other companies have successfully registered characters as trademarks, including Disney's registration of Mickey and Minnie Mouse. Importantly, since copyrights automatically expire after a period of time, but trademarks don't, a trademark can protect against unauthorized use of a character even after the work in which the character first appeared is in the public domain. Need to protect your trademark? Book an appointment with us at www.eonalb.com. Eon Law. Unleashing Genius.